So, quick disclaimers. Today's presentation is not intended as legal advice. This is for general information purposes. Although I am a lawyer, I am not your lawyer. Now, about me. I am, while I just mentioned I'm a lawyer, I'm more of a computer geek than an attorney. I've been working in IT since the 1990s. I've switched over to doing information security work 20 years ago at this point. I made the choice to go to law school because I had a frustration that existed between the communication gaps between technicians and attorneys when it came to notions such as contractual issues, when it came to interpreting regulations. Find smart people getting in a room, talking past each other for multiple hours, and getting upset and leaving and nothing getting accomplished. So my response, probably not sane, I decided to go to law school. Currently, my day jobs, I work incident response for a federal government agency. I don't work day in, day out, primarily focused as an attorney, but the information I learned while going to law school and practicing from time to time has been beneficial in what I do. Now, I'm also known for being relatively outspoken, which is a nice way of saying I'm on a windbag. Where this comes into play is that over the years I've worked on many different projects as help desk, as systems engineer, as sysadmin, as incident response. And in those environments, I've had an opportunity to work with some wonderful, bright, intelligent people who go off and do interesting things and sometimes get themselves in trouble. And a few of them remember who I am and come talk to me when that happens. And every time one of my peers finds himself getting in trouble related to something that they said or something that they posted online, one of the first things that come out of their mouth is, but I have a freedom of speech. Well, maybe. Even my mother, who passed away a few years ago, she knew nothing about law, didn't read everything, but the one thing she would repeat over and over again is, this is America and I have a freedom of speech. Well, in some cases, freedom of speech might not be available for all. Now, I like to take a moment, and I realize this might seem a little old-timey, might seem a little bit not relevant to a tech conference, but I want to take a moment and look back to the notion of what we think of as free speech in the United States. And that comes from, most people already know, the idea of the First Amendment from the Bill of Rights. Now, the wording on this is something that I'm going to try to get through this, and I'm hoping I don't have too many people laughing as I go through here. So it simply says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. Now, that portion, that little blue portion, or abridging the freedom of speech, is where all this notion that we think of in this country as, I have a freedom of speech, starts with. It's not even a full sentence. It's a sentence fragment, but that is one thing that is so well known, that's probably better recognized than any one other element of law, except for, well, we won't go too far down to the other amendments. But I'm a huge fan of XKCD, and I think that as we get into this a little bit, they hit this pretty nicely. So I'm sure many of you have seen this particular presentation, but I don't want to steal Randall's thunder on this one. But it's a reminder that when we talk about freedom of speech, we're talking about a restriction that the government has placed upon itself. This is not a restriction that prevents individuals referring to other individuals. It does not put a representation for a company on what they can or cannot do to you. This is the notion of a restriction of government action. The government will pass no law. Now, where that comes into play, especially amongst technicians, InfoSec, cybersecurity folks, when people run into issues or legal challenges related to something they've said or something that they have done, it normally comes in one of two buckets. One of them being a claim that what they've done is defamation, or B, that something that they have said or done is violating a contract that they are a party to. I'll go ahead and take a tour down through these maps. Now, defamation. Defamation is not exactly a new concept. This goes back historically. We see occasionally celebrity news items where one group is suing another. We'll see people upset about things that are put forward in the press. But it doesn't necessarily have to be the notion of something on a large scale. We're seeing more and more activity as it relates to social media come into play. Defamation, a simple definition, simply malicious or groundless harm to the reputation or good name of another in making a false statement to a third person. Now, I want to pause here for just a moment and contemplate that we think about defamation as, someone wrote something and it showed up in the New York Times and that person's claim is false and ruined their reputation. You do not need to publish at that level to trigger a defamation lawsuit. Simply stating something to a third person in an email, making a phone call, writing a note and handing it to that person, you have triggered enough of the requirements to equal the fundamental notion of defamation. Now, defamation per se effectively is the notion that you've said something about somebody or written something about somebody that has no way of having an instant meaning. And we're going to talk a little bit about some of the examples of that. Now, elements. One of the fun or perhaps horrible things that you go through in law school over and over again is every law, as you are looking to how it applies, will have a breakdown of what elements need to be met for this law to be right. So when we talk about defamation, we have effectively 4 elements. So the first element is simply a false statement provided as factual. Nothing particularly complicated there. Publication or communicating statement to another person. Now, publication is simple. You put it in, USA Today, you show it up on CNN, that's what. But the idea that communicating the statement to another person. So one area that I have personally seen people get into trouble with is somebody calls for a reference and they say, well, Bob might drink a little bit. And so you're talking to one person on a phone call that leads to them likely not getting that job. That statement, if it is false, could fall into the realm of defamation. Fault. The idea that the statement that you made, that you have some fault, that you were at least negligent in making the statement. And then finally, the fourth element is that statement needed to cause some level of damage. Now, in practical aspect, defamation can be a very difficult item to prove, and one of the difficult elements is often to prove damages. If you think through this, even if you know someone has said something bad about you, it's not always obvious how you can prove that that false statement or that damaging statement cost you a job, or even if you didn't get the job, how can you prove that that statement was the reason for that particular action? So this is one of those tripping points that makes it very difficult to come forward and be victorious at verdict in a defamation claim. Now, we talked earlier about defamation per se. So, got ahead of myself. The idea of when you have a statement that's made about a public party, so if you're talking about a politician, if you're talking about a CEO of a major company who is commonly in the press, the idea that the standard of that person claiming that something that else was said about them was defamation is a little bit higher. So you don't actually have just negligence. You must prove that the statement was made with actual malice. And this is one of the reasons that press organizations normally do pretty well in defamation lawsuits, because it can be difficult to prove that you went beyond just negligence in making a false statement, that you actually knew that your statement was false, that you went ahead with it anyway. You may have seen some news recently regarding Fox News is being sued by voting manufacturer. It's one of the cases where it's probably the best surface evidence I've ever seen of actual malice, so I'm glad I'm not an attorney for Fox News at this moment. But this goes back to a case that's well known and cited very frequently in New York Times v. Sullivan's. Now, examples of defamation. Defamation, my example earlier about someone making a statement that someone might drink too much, stating that somebody hasn't worked at a place that they had worked. Those are things that can commonly be considered to be defamatory. Now, defamation per se, as we discussed earlier, is a bit of a twist. It's the idea of making a statement that cannot have other interpretations. So the historical classic notion is that somebody has a loathsome disease. This came around a lot of casework around leprosy, on the idea that you need to stay away from somebody because that can be contagious. You can, in turn, be problematic. The idea that so-and-so is a criminal, that making that statement, that can move from defamation per se. And the key takeaway of being in defamation per se is that that last element of damages, you no longer have to prove that element of damages. That damages is going to be assumed, which makes the idea of winning a defamation case considerably easier. So something to keep in mind. Now, I want to take a refrain here just for a moment. I'm assuming that most people here are familiar at some level or another with the Electronic Freedom Foundation. If you are not, I would highly recommend spending a little time, go to their website. They have very good information regarding many things regarding speech, interest online for people who are either technology users or people who are technicians themselves. They have been doing very good work for many years, and I just like to take the opportunity to call out their work, and if you find yourself having questions, you could do a lot worse than checking with them about your particular concerns. Now, as we pivot over to the other bucket, this is where I find most people get caught up with in the discussions I've had, contractual matters. And on the surface, this can sound funny. It's like, well, what do you mean? What contracts could I have gotten into that could impact what I can say? Well, there are a lot more contracts that frequently have restrictions on speech than one might consider. Many people, especially if you're a technician, if you work on configuring items, or if you're someone in a purchasing power, you will frequently be asked to sign non-disclosure agreements. Now, these are relatively straightforward. Every now and then you'll have non-disclosure agreements that drift off a little bit, but the general principle is that someone's going to show you information and that you're agreeing not to disclose that information. Severance agreements have been in the news recently. We're going to discuss that for a bit. Employment contracts are a very large one. Employee handbooks, oddly enough. This is a weird space where, depending on what side the parties are on a particular issue, there will often be a fight as to determine whether an employee handbook institutes a contract or not. So if the employer feels that there's a clause in an employee handbook that mandates that someone does someone and they fail to do it, they will fight tooth and nail to say, yes, they agreed to this, they signed the employee handbook, this is a contract. If the employee handbook by chance happens to offer a reference to a benefit or something else that they don't want to live up to, they will shout up and down and slam the desk saying, no, this is not a contract, this is just some other document. So it's interesting how the same attorney in just a matter of minutes can find a way to be on both sides of that particular argument. But it is one that pops up in interesting places. More frequently than you would think, licensing agreements often have restrictive statements in them referring to limiting what you can say about a product. There have been some conflicting case law on whether or not that is a legitimate use of a licensing agreement, but it does happen. And settlement agreements. So anytime you have two parties that have already been in some type of dispute, they've come together and made an agreement, it's not unheard of for people to put in restrictions in that agreement saying you will not say anything derogatory, depending on what the wording is. But sadly, a lot of people don't bother to read the things that are put in front of them, so sometimes they're surprised when later they get upset and they say something and they get the nice little cease and desist letter saying that, hey, what are you doing? You can't say that you made this promise. So, as we mentioned earlier, non-disclosure agreements, relatively straightforward. Their intent and purpose makes a lot of sense for someone trying to build a new product, trying to enter into an industry, and they are hoping that their particular idea, their special sauce, is somehow not going to be given up or taken over by somebody else. So people take an effort to try to put forward a contractual restriction and say, hey, I will share this with you, but you've got to promise me that you're not going to share this with something else. In my experience, most of these are relatively straightforward. Every now and then, sometimes through carelessness, sometimes maybe for nefarious means, someone will write a clause in a non-disclosure agreement that will extend beyond the little special sauce that they have and talk about, you know, larger, broader issues that you can't even mention that you have seen them, or that if you have any thoughts on their, you know, that's generally not the intention or purpose of a non-disclosure agreement. And there have been some instances where overly broad non-disclosure agreements will be set aside if someone tries suing on them outside of the realm that most people consider to be non-disclosure agreements, but it's a gamble if you want to go down that road. Even if you find yourself having potentially said something outside of the scope of what a reasonable non-disclosure agreement has, if the agreement that's in question is very broad, it's a risk going forward, depending on what venue you have that heard on. With that in mind, I generally encourage people who are being asked to sign a non-disclosure agreement, number one, ask yourself, do you really need to go down the road with them? Because anytime you're signing an agreement that sets you up for potential litigation, there's a cost or a pain factor. You might not think about that, but it's out there. Number two, if you do have an interest and spend a few moments, read them. Normally these are much more than a page and a half. If it does not make sense, if what is being claimed in there is obviously beyond scope, push back. Because generally speaking, someone coming to you with a non-disclosure agreement often wants you involved, wants you to do something, and will often make those changes prior to the agreement. Now, while it's possible that someone can change the agreement after you've agreed to it, your leverage to encourage that change is much better before you sign that agreement. So something to think of to lower your exposure level, to make your life a little bit easier down the road should you have a falling out with whoever's coming to you at this time. Severance agreements. Severance agreements have been in the news recently. The National Labor Relations Board is an administrative office that spends a lot of its time overseeing impacts not only of unions, but of employment within middle to large companies. Now, they recently cleared a case just over a month ago at this point that said that you can no longer have restrictive covenants within severance agreements that prevent you from talking about conditions of employment at a company. This has been historically a relatively common practice. When people are getting fired or laid off, they'll offer you a severance package, and in that severance package, if you read the fine print, it says, we'll pay you X amount of dollars, but you cannot say anything about, you cannot talk about this, you cannot disparage, you cannot, any combination of items there. The National Labor Relations Board came out with a ruling that said that this is not valid. Companies cannot use a severance agreement to take action against employees for their speech. The general notion, Section 7, the National Labor Relations Act, references the idea of employees to be able to gather together, share information about the working conditions for the possible gathering of forming a union, forming other protective groups within a company. And if you squelch the ability for people to communicate with one another, it makes it very difficult for that possibility to exist. So the idea that the National Labor Relations Board said no. Now, this ruling is relatively new. I'm sure it's going to be challenged somewhat with borderline cases, edge cases. So I would not take that as a blanket statement that anything goes. If you're going to be, saying completely reckless items or malicious items, I'm sure that some employer is going to be willing to spend the money and time to go after somebody to see exactly how much room this particular protection has, but if you are an employee who has been let go, you now have much more elbow room than you did just a month ago. Now, for the timeliness of this, I'd also like to point out that many federal agencies pivot quite a bit based on administration. So, as has been the history for at least 2 decades, probably quite a bit longer, when Republicans are in the White House, effectively they change out the lead staffing at National Labor Relations Board, and they make that group very company focused. And so, if the next president or the president after that happens to be a Republican, we can anticipate changes that NLRB is going to change their view and say, no, employees can't actually say things or talk to people. And then if that changes back to a Democratic group, there's a very good chance that this pivots back and leans more to be friendliness toward unions, toward employees. So this might seem trivial, but keep in mind that the length of time that it takes for a case to go through hearings and go to trial can be tremendously long. So just because right now you have a Democrat in office, there's no guarantee there will be a Democrat in office when the case is actually heard. So this ruling, this had been something that had been put on the front burner within weeks of the Biden administration coming into office, and they just got to it February of 2023. So it took them 2 years after the administration landed to make this change, to get a case through and come up with this ruling. So as we who spend time in technology, our idea of change and the timeliness of that doesn't necessarily play well with the time frame change in law and regulation. Employment contracts. In the US, there's not an absolute need to have an employment contract if you're working for someone either as an employee or as a contractor. But frequently, there will be an employment contract. And if an employment contract exists, then the clauses in that contract are simply changing the default terms that exist between employee and employer. It's really nothing more complicated than that. Historically, the courts have been very lenient with companies who want to go ahead and place restrictive clauses upon their employees within contract. We, as a nation, we have been very big on the right to contract and allowing some particular items. Where that gets pushed back on is when you run into conflicts with law or regulation. So when you have child labor laws, when you have, which in some states, I believe Arkansas just made announcements that they're working on rolling back their state child labor laws because they, for a period of time, were more restrictive for child labor than the federal government, and now their new governor, she doesn't seem to think that having kids work in coal mines is a big deal. So, yay Arkansas. Some of the clauses that we'll see in employment contracts that come into play here: arbitration clauses, non-competes, non-solicitations. I had not actually seen a non-derogatory statements clause until recently, and that one became a bit of a headache for someone I was helping. Venue and forum selection, choice of law. Some employers will place in restrictions that state you can't work someplace else while you're there. So the idea that you must dedicate your working time to that employer. And a little bit out of the scope of this talk, but comes up quite frequently amongst the people who come to me, is intellectual property restrictions. The idea that while you're working at a company, anything you're doing there, the ideas you come with, products that you come up with, they are potentially, the ownership belongs to the company instead of to yourself. And for those people who have aspirations of building a new program or building a new technology or expanding some technology, even if what you plan on doing is open source work, this can be a tripping point that you should be aware of what you've agreed with your employer before you go forward. Arbitration. Arbitration, there is, my apologies, good, bad, ugly. So arbitration has become a larger and larger animal in the U.S. legal system. And largely this is because the legal system is quite honestly swamped. There are more cases, both civil and criminal, than can possibly be dealt with. We have not significantly grown the courts out for decades. So as more demand is going through, there are no more judges, there are no more staff for courts to handle these requirements. They've taken efforts to modernize, improve notions of submitting cases, but there's a limit to how far the existing system can go, and most judges are simply swamped. With this in mind, courts all the way up to the Supreme Court have been very supportive of the notion of arbitration. Anything you can do to move cases out of the court system is considered to be a good thing. Now, as you'll see here shortly, I have my qualms with the notion of arbitration as it's actually practiced in the United States, but it's not entirely a bad thing. Number one, it does address some of those concerns that we have about the overflowing court systems. It gives you another place for a case to be heard. Generally speaking, it's not nearly as time-consuming to have a case heard in arbitration as it is to have it heard in a court. It's the procedures, especially if you're representing yourself, are far less Byzantine than they are in a court system. It's much easier to address the needs of an arbitrator to move your case forward. If it's something that is of keen interest to you, if it's something very important, it's probably still very much in your interest to have a representative who is familiar with that particular form and can help you through this. But it is more approachable as a pro se representative than the courts are in general. The bad. Now, where I often come in are people, former coworkers, friends, people I've known. They have made a statement about somebody. They've said harsh things about software in a review or a particular security tool. They've said things about their employer that their employer is unhappy with. They are often very upset. They're often worked up. They feel that something is wrong and something needs to be said and people need to be able to hear this. Generally speaking, arbitration is a closed system. Arbitration dockets not visible publicly. The things that are shared in arbitration are not going to be seen. There's often, not required, but often gag orders placed on parties within arbitration that prevent you from talking about the details of what comes place in arbitration. So if your origin point, if your starting point at this was something is very wrong, I have been wrong, these people have been wronged, the idea of taking your matter and having it heard in a system that nobody can know about it is generally not the solution that you want to have. But the reality is that courts are very fond of the notion of arbitration, and especially if you have agreed that your disputes will be handled through arbitration, through an employment contract, through a severance agreement, through something along those lines, it can be very difficult to get that set aside and allow your case to be held outside of arbitration. And this is something that pains people greatly. So sadly, by the time you get to the point you have that conflict, you're quite possibly too far down the road to have good chance of the outcome that you want, at least as far as being heard, which is why I do encourage people to pause and think about those contracts they're signing. Look at your contracts, how many of them have arbitration guidance in there? Do you have the leverage if you're working for a shop, especially a small to medium-sized shop, to request that, hey, let's modify this arbitration, let's limit the scope of this. And it's very difficult at the start of a relationship to think about how things might go badly. Because when you start a new job or you go into a new business venture, we're all optimistic, we're all hopeful that things are going to be bad. But one of the things, when I put my lawyer hat on, is I try to advise people that, yes, everything's wonderful, it's great, but what is going to be when things get ugly? What positions and what options are you going to have down the road? And looking at that at the start of a relationship, so much easier to deal with than it is at the end of a relationship. Now, the ugly. For individual computers, executives at companies, as a single person, who has found themselves on the wrong side of a conflict with their former employer or someone on that line or a group they contracted with, and they find themselves in arbitration. You as an individual, even if you are a very seasoned individual, it's unlikely you're going to find yourself going into arbitration on a regular basis. You are a seldom user of arbitration. Whereas the company, especially if it's a medium to large size company, there's a very real possibility that they've used arbitration numerous times. They are going to be familiar with the arbitrators within a particular pool. Oftentimes, arbitration clauses will make promises that the company will pay the bill for the arbitrator. That makes it a little bit easier for you as the party going into this to cover that, but that not necessarily all the bills, but at least the arbitrator's bill. Then both parties get to say or push back on who is put forward as an arbitrator, but that pool of arbitrators that are going to be pulled from, the organization you're working against is very likely to have a better understanding of who those parties are. And because for the people who work as arbitrators, they know that they're being hired by companies. They know if they want to be hired down the road as they continue on through their career, if they consistently side against corporations or companies in their rulings, it doesn't take that long for companies and corporations to realize that maybe this isn't an arbitrator who should be in our pool. So this creates the possibility of a bias, unconscious or otherwise, that an arbitrator is going to be challenged to bite the hand that feeds them. And we've seen numbers that if you look at cases that are gone through arbitration compared to those that go through the courts, there is a significant delta in the percentage of cases that the individual wins in arbitration compared to that of trial courts. So it's not an insurmountable hill, but very frequently as the individual contributor, you don't want to be in arbitration. Non-compete clauses. Many of us have probably worked someplace at some time or another that have non-compete clauses. Some of these clauses can be very, very restrictive. Fortunately for employees, over the course of time, the courts have said for public policy reasons, we want people to be able to work. Because if people are working, they can pay taxes. They can feed their families. They can buy a house. They can do all these things that we as a society, as a public, want them to be able to do. So courts have, in general, been skeptical of anything that sets up restrictions for people to be able to find work. But courts will weigh that against the notion, is there a valid interest of the company that if people are going to cross the street and work for the competitors, that it can legitimately harm that company? So generally speaking, and it varies a little bit by jurisdiction how this will work out, they will require that for a non-compete contract clause to be held up, it has to be of a reasonable duration. And reasonable duration, as an individual, you might think, well, a few weeks. This can very often, many jurisdictions allow 1 to 2 years of time that you can be restricted from working in a particular place. They will often put on reasonable geographic restriction. So the idea that if you say, well, you can't work within the state of Arizona, well, that's very fewer people are going to consider that to be a reasonable restriction. But they might say that, okay, you can't work within 10 miles of this particular location. That will generally be allowed or accepted. It's a sliding scale, so the more aggressive they are in geographical restriction, the more aggressive they are in time duration, the more possibility of pushback. And there's also the notion of reasonable limitation. So courts can be less favorable to a company that says you can't work in any notion for the competitor compared to if they say, well, you can't do, if you're a plastic surgeon who specializes in eye lifts. And it's like, okay, well, you can't work doing eye lifts within a 35-mile radius here because you're going to steal business from the company that does this. But you can go do other types of surgery as a general practice. So the more restricted that is, the more likely the court is going to uphold that particular restriction. So the whole notion that has developed over time is a balancing of not necessarily the employee's best interest, but of the public's best interest against that of protecting the employer who put forward the clause in the first place. Now, the historical rule when a non-compete clause has been too broad is to strike the entire clause. And so this is the incentive to get companies to restrict that to a reasonable level to have a better chance that their clause will be held up and to discourage people from making crazy over-the-top requests. Now, I bring that forward. Non-solicitation is very similar on the idea that you worked at some place, you found some really good coworkers, and now you have the new job directly across the street, and I want to hire all these people. Very similar, that courts will go through this balancing act of what is the rights of the people to have better jobs, what do we want as society, compared to what is valid for the protection of the business. So once again, if you scope this narrowly, the employer is likely to be for it. If you scope it very broadly, don't put time restrictions on it, it's quite likely to be set aside. Now, the reason I brought those up specifically is this is a clause I came across recently. I'm not going to read it to you, but if you take a look, what bothers me about this clause is this isn't a non-defamation, this is a non-derogatory clause. So this is the employer effectively saying that you can't go on and say anything about us we don't like. There's not even a requirement that what you're saying not be true. Just anything that they decide that they don't like, which in my mind is an insanely broad notion. Also notice, I don't see anywhere in this clause that there's a time restriction. Now, many people who work in IT and information security are young. If you're in your 20s or 30s and you sign a clause, you sign a contract with someone that says you will never say anything bad about them, I will tell you as an old geezer myself that 30, 40, 50 years, it's a lot of time. And the idea that it's, in my mind, insane that a employment clause can be put forward that for 50, 60 years, not for national security, not for the well-being of the nation, but because some executive at some company has thin skin, that a person can't say anything about them. Now, where I've seen this run into difficulty for companies is the notion that, well, it's easy to prove that someone said something that is derogatory, that's something that made them feel not good about themselves. Okay, that's an easy bar to clear, but it's very hard to show damages. It's like, okay, well, someone said something mean about me on Twitter or on Instagram. But what is your damage? Well, in an arbitration that I can't talk about the specific details, we saw a company go after someone claiming $1 in damages and amounted to in excess of $400,000 in legal fees. Perhaps you're doing better than I am financially, but $400,000 would definitely put a dent in my operational budget for the year. And the legal fees in that particular case amounted to a half-day arbitration hearing and a handful of attorneys scraping images off of a social media site and screen capturing them and writing the complaint. So imagine if you were dealing with a case that actual work needed to be done. That number can get really ugly really fast. So if you find yourself being offered a job, considering doing contract work for somebody who has a clause that looks something like that, I really suggest you go someplace else really, really fast. Clauses we don't often think about. Choice of venue, choice of forum, choice of law. As we go about our business, the last few years I've been working primarily from my basement, so I don't travel nearly as much as I used to. But it is a big world, it is a big country. I live in Northern Virginia, right outside Washington, D.C., so I drove here. It took me about 11 hours in my little Volkswagen GTI to make the trip. Nice. It's a lot of flatness in Indiana, in case anyone was wondering. Really, really flat. But in a contract, it's quite possible that there might be a choice of forum or choice of venue clause that might state that any disagreement that rises from the contract or from this employment contract, from the employment that came from that contract, will be held in a certain location. So if you work for a tech company where their headquarters is in California, you might well have a clause in your employment contract that says, well, if we're getting a lawsuit, we're having this in a court in California. If you don't live in California, that could be inconvenient for you. I was personally sued for defamation when I was in grad school. I was going to grad school online at the extension school for Harvard, and one of my fellow students got upset with me, and he sued me and 17 other parties, including the school, for many things, but the lead one being defamation. Because I referred to him, as he quoted in his case, 4 words. He said, I referred to him as a fool, a loon, an ass, and an embarrassment. And I have said all those things about them, and I continue to say those things about him. But he sued me in the courts in Massachusetts, and I was, of course, living in Virginia. I tried to persuade the court that they did not have personal jurisdiction over me because while I went to an online school, I did not actually reside or work or otherwise function in Massachusetts. But the courts decided that no, he was in Massachusetts. We had the commonality of both going to the same school, so that was enough. So I got a chance to make 13 trips over the course of 7 years to defend myself for saying that he was a loon, an ass, a fool, and an embarrassment. I eventually did win on summary judgment, but he's now had 2.5 years into his appeal that is still ongoing. So now being 2023, these are statements made in 2011 on April Fool's Day, 2011. By the way, if you're going to have a conference at a major university where your speakers come forward and say the biggest problem with this country is that we haven't managed to kill all the witches, may I suggest you don't hold that on April Fool's Day. Just a little bit of advice. But anyway, I digress. So these contract clauses are ways that you can find yourself defending yourself in a place that you might not have thought of. So it's worth taking a little time, looking over the contracts before you start a new job or a new contract. What are you potentially getting into? Choice of law is an interesting one in the notion that our courts will accept the idea that you might be sued in your home state, but they could have a restriction that says you will use the law of some other state. This sometimes creates some unusual circumstances because, let's say, the courts of Massachusetts aren't necessarily particularly good at applying the laws of, say, Arkansas, but from time to time they'll try, and occasionally unusual things will come from that. One of the areas that in my personal lawsuit for defamation, I reside in Virginia, and I made the argument that in Virginia, the statute of limitations on defamation is 1 year, whereas in Massachusetts, they had a larger window. So even though he by far missed that requirement in Virginia, because they were using the law of Massachusetts, in Massachusetts, that longer window did allow that case to move forward. So there are a lot of tweaks that can change from jurisdiction to jurisdiction. So even if you do happen to know or understand the laws as it relates to your speech in your home state, the internet's a big, broad, beautiful place, and there are a lot of jurisdictions that are being overlapped. It's nearly impossible going into any statement you make online to know all the potential places that could come into play with that at the time. It's only after things have fallen apart and people are now throwing things at each other that you start getting dug into the notion of what rules apply and how they're going to impact your case. So even if you get to the notion that for all practical purposes, you're not going to be guilty of defamation, you're not going to be in violation of your contract clause, you're not necessarily out of the woods on the idea that one of the lovely, beautiful things about our legal system is that effectively anyone can sue anyone else for practically anything. You can choose to sue me for blocking your view of the space aliens on the horizon. Even if there are no space aliens on the horizon, doesn't necessarily mean the suit can't be brought. Very unlikely to win, but the notion from the time that a lawsuit is brought to the time that it's cleared can be much longer than most people think, even in cases that on the surface don't make a lot of sense. As I mentioned in my personal case, the 4 words that I was accused of using pretty well fall in most people's definition of opinion, but it took me, in the sort of 5 to 6 years to get a summary judgment on that. I was defending myself in that, so it kept my legal fees somewhat low, but I did make numerous trips back and forth to Massachusetts, and I was very fortunate at the time that since Harvard was also being sued, Harvard has some very good lawyers. And since they were being sued largely on the same grounds that I was, I got a chance to see what they filed, and I used that to shape a lot of my thoughts and opinions. So creative borrowing, as they might refer to that. Now, if you find yourself on the receiving end of one of these legal threats or a lawsuit, even if you're going to get to the point of it being dismissed, it can still have significant legal fees for you. It can take a tremendous amount of your time. There can be travel involved with you, especially if you're in a jurisdiction that's not your own. Even if you're fortunate enough to be sued in your home state, if you live in a relatively large state, it can be a long ways to whatever place within the state they decide to hold the trial. Those of you might happen to remember from the opening, my last name is Vedaa, which is not good for courts that decide to hold their docket in alphabetical order. So you can spend a lot of time at a court waiting for your particular hearing to be heard because they are overstressed, overbooked. Things that would think be 15, 20 minutes can be all-day affairs for every bite. So these things take time. And most people, if you're not an attorney, a threat of legal action or an actual lawsuit, this isn't your primary goal or function in life. You have other things you want to do. You want to work, you want to be with your family, you want to be at school, you want to be further in your life, you want to be out running, whatever, go and see the movie. This is time taken away from your existence that you are simply not going to get back. Now, long-arm statutes. As I mentioned, my personal experience with getting a chance to visit Massachusetts multiple occasions, we are seeing, there's always been some level of forum shopping that takes place by parties who happen to be well-funded enough or motivated enough to try to bring a legal action in a place they think is favorable to the outcome they want. I think we're seeing that taken to a new level recently in some of the lawsuits that are being brought, specifically in Texas and in certain jurisdictions in Florida, often politically minded items. So we have a case in Amarillo, Texas, where they're challenging the idea that the FDA had approved a medication that can be used for medically induced abortions. And this has been an approved medicine for 20 years, and now they want this judge in Amarillo to make a determination, should the FDA be allowed to approve drugs? Now, it's very likely that this particular judge is going to say no, that FDA can't do that because he has very clearly established he has axe to grind. And so we see the FDA and others making their way to Armadillo, Texas to participate in this item. I can tell you that the FDA has a very, very, very small footprint in the greater Armadillo area. So yeah, it clearly wasn't to be where all the people who had input to the decision were. But on individual matters, the idea that sometimes, instead of for favorable location, someone can try to bring a suit in a particular location because they know it's going to be inconvenient for you. So sadly, as an individual contributor, as a technician, if you find yourself in one of these particular lawsuits, the idea that it's easier for a company to spend money than it is for an individual. Even a relatively small company is likely to be better funded than a relatively well-to-do individual. So this is just one of those problems that come into play. Now, you can often battle this, and you might be able to make an argument to get a court to buy in on the notion that no, they do not have jurisdiction over you. No, this isn't the proper forum for this particular, but it is a challenge that needs to be worked through. And even if you are successful, you often have to make one or more trips to that jurisdiction to make that argument to get yourself moved over to some other court. Now, some jurisdictions, such as Virginia, have unusual ideas within their law. Now, I reside in Virginia. I am not a member of the Virginia Bar. I'm a member of the DC Bar. But the long-arm statute in Virginia specifically can be interpreted in a manner that if you do any action that can impact a system in Virginia, then the courts in Virginia can have jurisdiction over that case. Now, if you've never spent time driving around Northern Virginia, there are an epic boatload of data farms, server farms in Northern Virginia. They are all over the place. Major providers from every service, Amazon Web Services, they have some of their biggest server farms there in Virginia. So if you state something on a social media platform, if you send an email to something, there is a very, very good chance that somewhere along the way that made a change to a system in Virginia, and theoretically that gives an attorney the ability to argue that Virginia should now have jurisdiction over the actions from that item, which I personally think is insane, but it appears to be part of the argument used in, I am not that much on celebrities, but I believe Johnny Depp had just had a relatively large defamation case in Virginia, and neither of them have strong ties to Virginia, but basically because the communications took place, they used that argument to bring that into the Virginia courts. So I suspect that's not the last we're going to see. So if any of you do get sued and end up in Virginia, drop by, maybe we can have a drink. So the long-arm statutes, there's a legitimate need for the idea of long-arm statute, and predominantly the historical notion went back to the idea of a case called International Shoe. This is a fun thing that law students get tormented with in their first year of law school. And the idea that this mail-order, door-to-door shoe sales company, International Shoe, was being sued because apparently their shoes stunk, I guess. And the notion that International Shoe said, well, no, we're in this. We're not in these other places. We just sent shoes to people. We mailed them to them. We can't be considered. And the courts came down with the notion that to have physical jurisdiction, personal jurisdiction, something, you have to have some type of interaction with that particular party. Normally, it's doing business in a particular area, having a presence, using their courts or their legal system, using that jurisdiction's resources. Those are all things that can trigger that action. But the internet has made that muddier. What is, when you are on Facebook, when you're on Twitter, when you're on Instagram, when you're communicating with people from all over the country, all over the world, where are you doing business? The courts continue to struggle with that. And as such, people are going to make the notion that they were harmed where they were, or they were harmed where their family was. And there's not necessarily a right or wrong with this. It does leave open the possibility of forum shopping, that notion that somebody who has an axe to grind might try to find an argument that will bring you into a jurisdiction that's least favorable to you. And you just need to be aware that things are often not as cut and dry as you think going into a particular item. So time, as I'm running near the end of my hour, I think this is appropriate to have this. In our world, things move fast, things change quickly. In law, not so much. There's a celebrity who is now being sued for having run into somebody on a bunny slope, Gwyneth Paltrow, I believe it is. Now, the argument of, did the obstetrician run into her? Did she run into the obstetrician? Who knows? But 7 years after a collision on a bunny slope, we're now in a trial. Think about that for a little bit. How trivial does it sound that two people bumping into each other on the bunny slope, 7 years to get to a court? So keep in mind that these things have a really, really long tail. Good news, bad news, most cases that are threatened or brought don't actually make it to verdict. The vast majority will either get dropped because it's just not worth pursuing, or people will choose to make a settlement. Numbers have ranged as high as 85, 90% of cases that are threatened never actually get to verdict. But that doesn't necessarily mean there's not going to be impact, cost, or damage to you before you get there. I think we might have time for one or two questions if anyone is so inclined. Nope, I have no time, so I am done. Thank you very much for your time. I appreciate it.